The current federal civil law, the Defend Trade Secrets Act, specifically provides for the U.S. trial courts to handle matters involving foreign misappropriation. It wasn't always that way. Back in the day before 2016, we primarily handled civil disputes under state law. And state law generally requires that the misconduct occur within the state where the claim is brought. Well, the new federal law in 2016 changed that, and the legislative history specifically shows that Congress wanted the ability to regulate the foreign misuse of U.S. technology and trade secrets. So the Defend Trade Secrets Act provides in one of the statutes, it's 18 U.S.C. 1837, that the Defend Trade Secrets Act has applicability to conduct outside the United States. And this provision originally was part of the Economic Espionage Act, but when Congress enacted the Defend Trade Secrets Act, it imported this statute into the Defend Trade Secrets Act. Now, some counsel have argued that the applicability outside the United States doesn't govern civil cases, but courts have uniformly held that it does. And so what does that mean here? When can a foreign misappropriation be actionable in the United States? Well, as against a foreign wrongdoer, whether it's an individual or an entity, what the law says is it looks to whether an act in furtherance of the offense has occurred in the United States. So how does this play out in the real world? Well, I'll give you a couple examples. One is, suppose you have a U.S. trade secret owner, and it's in a collaboration with a foreign partner. And that collaboration takes place over a period of time, and the U.S. trade secret owner shares those trade secrets under non-disclosure provisions. But that collaborator later goes rogue, and it starts using the U.S. trade secret owner's trade secrets for itself outside the United States. What can the U.S. trade secret owner do? Now, another example would be many U.S. employers have employees outside the United States, and the employer shares company trade secrets with its employees who are located outside the United States. Some of those employees leave, and they either go to a startup or to a competitor, and there are times when those foreign employees are using company trade secrets. So what's at issue here is how can that U.S. trade secret owner bring an action against either the former collaborator or the former employee in the United States when that foreign actor is exclusively doing its harmful activity abroad? So this brings up now, what exactly is an act in furtherance of an offense? Well, there's some guiding principles in the law. One is, it need only be a single act that qualifies. Another is, it need not be by the defendant. The act could be by a partner, by a vendor, by a supplier, so long as it is part of the overall conduct at issue in the misappropriation. The act need not be an element of the offense. One thing that is critical, though, is that the act must be part of the offense and take place during the misappropriation period. The act cannot be before the operation began, and the act cannot be after the operation ended. So the courts have provided specific examples of what constitutes an act in furtherance to trigger the U.S. court having jurisdiction over a foreign misappropriation. The first example would be contact with U.S. servers. Many people involved in misappropriation abroad make contact with U.S. servers in their wrongdoing, and it may be by downloading company information from U.S. servers, or it may be in storing stolen trade secrets on U.S. servers. And courts have found that that touch with the United States can constitute the requisite act in furtherance. Other examples of what companies have done that have been found to constitute acts in furtherance are in recruiting engineers or other technical employees to go abroad to join the project. The recruiting of personnel in the United States can constitute the act in furtherance. Another example is when the foreign wrongdoer purchases supplies or equipment from U.S. suppliers. It might be engineering equipment, it might be chemical supplies, but any acquisition of supplies and equipment from the United States can be that act in furtherance. Any visit to the United States associated with the enterprise of the wrongdoing could constitute an act in furtherance. And aside from a physical visit to the United States, courts have also found that virtual contacts with the United States can constitute an act in furtherance. That virtual contact can be by email, it could be by Skype, it could even be a Zoom participation in a board meeting or other scientific advisory board meeting that's occurring in the United States, and the zooming in to that meeting can be an act in furtherance. And then yet another example would be, believe it or not, a lot of foreign misappropriators apply for U.S. patents on the stolen technology, and the action of applying for the U.S. patent can be an act in furtherance of the foreign misappropriation. So how does the defense combat the act in furtherance? Well, there's several ways. First, the defense might say there is no act. We did not touch the United States, very deliberate about it sometimes, and the defense sometimes argues no act occurred. The fallback to that might be nothing was in furtherance of the misappropriation. Well, we might have done an act, but it was not in furtherance of any alleged misappropriation because that act falls outside the time period. It was before the operation is alleged to have begun, or it is after the time that the operation is alleged to have concluded. So that act was not in furtherance of any misappropriation. A variation of that is the alleged act is just too unrelated to the misappropriation. You're claiming an activity occurred in the United States and it might have been within the relevant time period. It's too remote and too unrelated. Then another challenge a defense might make to an act in furtherance is, well, it was never stated in the complaint. And believe it or not, there's a lot of complaints alleging foreign misappropriation where they never allege the act in furtherance of the misappropriation in the complaint, and it needs to be there. And then finally, defendants may argue that there's a failure of evidentiary proof. There's noise of an act in furtherance, but the defense argues there's an inadequate evidentiary showing of the act in furtherance either at summary judgment or at trial. And as a consequence, the federal district court, the defense argues, lacks subject matter jurisdiction to hear the matter. So we get to the final question, which is, why does this matter for a U.S. company to have the ability to bring a trade secret claim in the United States court versus in a foreign court? Well, there are several reasons why it's very meaningful. This issue of whether a foreign actor engaged in an act in furtherance of the misappropriation is pivotal to whether or not the U.S. court can hear the matter or if the U.S. company has to pursue the matter in a foreign court, if at all. Discovery is important. By and large, the United States allows more discovery than other jurisdictions. And in trade secret matters, there's often a need for some discovery from the defendants in order to prove all of the elements of a claim. So the ability to get U.S.-style discovery can be very meaningful to the successful prosecution of a civil trade secret claim. Remedies matter. Generally speaking, the United States has more robust remedies, both monetary and non-monetary, for a trade secret claimant. So it's meaningful that a plaintiff can get into the U.S. district court to pursue the civil trade secret claim. Right to a jury matters. Not all countries offer a right to a jury in a civil trade secret case, whereas the United States does. And that can be meaningful to the outcome of a case. The U.S. evidence rules can be helpful in the bringing of a U.S. trade secret case. And then finally, just the overall familiarity that a U.S. company has with the U.S. court system can be very helpful in the bringing and pursuit of a civil trade secret claim. So for all these reasons, it's very meaningful that the Defend Trade Secrets Act allows for the bringing of a civil claim in the United States against a foreign wrongdoer in these circumstances.